Good afternoon, everyone, and welcome. Thank you for joining us today for Contemporary Issues in International Investment Law, a program organized by the Turkish Arbitration Academy and the İbni Haldun University Dispute Resolution Application and Research Center. We are now streaming live at YouTube. We have an excellent program ahead of us, 2 opening speeches followed by a panel session with distinguished guests from Washington, D.C., the Netherlands, and Ankara. Let us begin. First opening speech. For our first opening speech, I would like to introduce our first speaker. She serves as a Vice Rector of İbni Haldun University and Director of the Dispute Resolution Application and Research Center. Please welcome Professor Dr. Yeliz Bozkurt Gümrükçüoğlu.
Thank you. Distinguished guests, dear colleagues, it is a great pleasure to welcome you all to today's event on contemporary issues in international investment law. On behalf of İbni Haldun University and the Dispute Resolution Application and Research Center, I welcome you. International investment law is now an important part of global cooperation and fairness. Events like this help us build shared understanding. We are honored to host distinguished speakers. I would like to thank everyone. I wish you a productive session. Thank you.
Thank you very much, Professor, for your remarks. Now we are continuing our second opening speech. Our second opening speaker is the head of the department at Director General for Law and Legislation under the Secretariat General of Presidency and a member of the Coordination Board of the Turkish Arbitration Academy. Please welcome Assoc Professor Eda Manav Özdemir.
Thank you. Distinguished speakers, guests, and arbitration practitioners from around the world. It's a great honor to welcome you all to this significant webinar on current issues in international investment arbitration jointly organized by the Turkish Arbitration Academy and İbni Haldun University Dispute Resolution Application and Research Center. It is a pleasure to open this discussion focusing on the evolving definition of investment, the development of the fair and equitable treatment standard, the increasing recognition of the state's right to regulate, and the future of bilateral investment treaty practice, including the recent approach of Türkiye. The International Arbitration and Alternative Solutions Department in the Directorate General for Law and Legislation in the Presidency has full authority to represent the Republic of Türkiye in investment arbitration cases against Türkiye and coordinates all such proceedings working in close cooperation with relevant governmental institutions. In 2021, the Secretariat General of the Presidency of the Republic of Türkiye, İbni Haldun University, and Istanbul Ticaret University signed a cooperation protocol that led to the establishment of the Turkish Arbitration Academy. The Academy aims to promote arbitration culture in Türkiye, support academic research, provide training, organize conferences and workshops, and cooperate with national and international institutions to contribute to the development of arbitration. As a country with a growing role in international investment and a dynamic arbitration practice, Türkiye closely follows global developments and ensures that its dispute resolution framework remains aligned with evolving international standards. The Turkish delegation actively participates in international platforms, including ICSID and Ancestral Working Group 2 and 3, and contributes to these processes in coordination with the ministries and institutions. International investment law has undergone significant changes in recent decades. Treaty practice shows a shift toward clearer definitions of investment, more precise formulations of the fair and equitable treatment standard, and a stronger recognition of the state's right to regulate in the public interest, particularly in areas such as environmental protection, public health, and economic stability. New generation investment treaties seeks to establish a better balance between investor protection and regulatory autonomy. Foreign investments in Turkey are protected through bilateral investment treaties negotiated by the Ministry of Industry and Technology. Turkey has concluded several BITs, which remain essential for ensuring legal certainty for investors. These developments demonstrate that the investment treaty system continues to evolve. I hope that this webinar will contribute to a better understanding of these ongoing changes and the future direction of international investment law. I would like to express my sincere gratitude to our distinguished speakers for sharing their significant expertise, and I also thank all participants for joining us in this important webinar.
Thank you, Professor Özdemir, for your valuable contributions. With now our opening speeches complete, we move to the panel session. Our moderator needs no lengthy introduction. He is a faculty member at İbni Haldun University School of Law and a member of the coordination board of the Turkish Arbitration Academy. I am pleased to hand over to my professor Ali Yeşilırmak, who will guide us through the rest of the program. Professor Yeşilırmak, the floor is yours.
Thank you very much. Dear friends of arbitration, distinguished members of the panel, our first speaker is Csaba Rusznak. His title of his presentation is Investment, Current Understanding and Future Opportunities. Csaba is the founder and managing member of Sovereign Arbitration Advisors, a Washington, D.C.-based boutique law firm specialized in resolving disputes involving states and state-owned entities. Throughout his career, he has represented states and their agencies in international investment arbitration, commercial arbitration, and arbitration-related litigation proceedings. Previously, he worked at a large multinational law firm. Since 2020, he has served on the panel of conciliators of ICSID, having been appointed by Hungary. Most recently, he represented the Republic of Türkiye in an energy investment arbitration, and the state prevailed in that arbitration. Csaba, welcome.
Thank you very much. It's a pleasure to be with you.
Thank you. And now I will have three questions to you. My first question is, how would you characterize states' approaches to the definition of the term investment?
Well, again, thank you so much for the kind invitation to participate in this webinar. And in answering that question, I think perhaps we might take a step back and ask ourselves, why is the definition of the term investment important? And I would like to address that question from a practitioner's perspective. I myself do much more counsel work than I do academic work. And so I thought that perhaps my contribution on this panel could be to offer the perspective of a practitioner who has done many of these cases, particularly on the side of the state. So bearing that in mind, I think the definition of investment is critical because, of course, only an investment enjoys treaty protection, whether under a bilateral investment treaty or a multilateral investment treaty, such as the Energy Charter Treaty or NAFTA or CAFTA, for example. Traditionally, the definition of investment has been very broad, and that has been intentional because states in crafting bilateral and multilateral investment treaties wished to encourage as much investment in as many sectors as possible. And so if we look at the language that investment treaties use, we will see that the definition of investment is typically, not always, but typically formulated in a very broad way. And the examples that are enumerated for what falls into the definition of investment are also numerous, and they cover many different types of assets. For example, stocks or shares in a corporation, physical property, land, buildings, debts or debt instruments are also typically considered to be investments. In addition to that, when we talk about the ICSID system, there is another test that we typically look at called the Cellini test. And the Cellini test really goes to what are the factors that would indicate the presence or the absence of an investment. And I just very quickly share some of those attributes with you. One of them, the first rather, is a contribution that has to be made by the investor. It has to have a certain duration. It cannot be a fleeting, very quick contribution. There has to be an assumption of risk on the investor's part, and the contribution has to contribute to the development of the host state. Now, I would wish to emphasize that the case law on the Cellini test is constantly evolving, and it's actually quite rare for states to be able to defeat the definition of an investment on the Cellini test. Tribunals have tended to err on the side of being very liberal when it comes to interpreting what an investment is. But nevertheless, it's those two sources, the treaty language itself, and then if you're within the ICSID system, the Cellini factors that would help you as a practitioner determine whether you in fact have an investment or whether you can argue against the existence of an investment.
Thank you, Csaba. There is a related question, my second question. What are some important limitations on how international law understands investment?
I think one of the most important ones that I would highlight for the participants in today's webinar is the requirement that the investment has to be made in accordance with the laws of the host state. This is something that traditionally has been understood to be present in a treaty, even if there is no specific language that indicates this. Investment arbitration tribunals over the years have concluded that even in the absence of treaty language that says this specifically, there is nevertheless a default requirement that the investment must be made in accordance with the laws of the host state. Now, what does that mean for practical purposes? What it really means is that if you are making an investment as an investor, and your investment is not in accordance with the laws that govern that particular activity in the host state, even if your contribution meets the requirements under the treaty or under the Cellini test for being an investment, your lack of respect for the host state's laws or your non-compliance with the host state's laws effectively strips you of that protection under the bilateral or multilateral investment treaty. So I would wish to emphasize that certainly for investors, acting in accordance with the host state's laws is critically important. And if you are approaching the question from the standpoint of the host state, you would really want to look at whether or not the investment was made in accordance with your laws. And if it was not, there is a good possibility that that particular investment, even if it otherwise meets the definition of investment, nevertheless would not qualify for investment protection.
Thank you. So, in your view, what does the feature bring to us in respect of our understanding of investment?
I think a very interesting development that we're seeing and that I personally believe will accelerate, and Professor Özdemir already alluded to this, is the evolution of how we think about investment and the definition of investment. States, of course, are the ones who are negotiating these treaties between one another. And I believe we will hear from other panelists this afternoon who can certainly speak more to the considerations that go into these various approaches on the part of states. What I would simply say is it's always been interesting to me as a practitioner why states don't take a more restrictive approach to the definition of investment. Investment protection, of course, is a very expensive thing to give, in a sense, because if you as a state end up in an investment arbitration, your risk exposure can be quite significant. So it's always been interesting to me, for instance, whether states might wish to limit the protection that they give to investments to target industries that they would like to develop. Or, for example, they might decide to limit the definition of investment to projects that are above a certain value threshold, perhaps $5 million or $10 million, whatever the case may be. So I think there's tremendous room for customization. Maybe that's the right word. There's tremendous room for customization in how states think about and define investment and what investment projects they are willing to give protection to. Now, as I mentioned at the beginning of the segment, I think when many states were drafting their bilateral and multilateral investment treaties, there was an emphasis on trying to attract as much investment from as many investors in as many sectors as possible. And I think that certainly makes sense. But as many economies mature and as many economies take a more nuanced view of which sectors they would like to see international investment in, I would not be surprised, and I fully expect that the evolution of how we think of investment will continue and will in fact accelerate. And we're seeing this interestingly, just one example I would offer, with the renegotiated Energy Charter Treaty, which takes a much more particularized view of what an investment is and what sorts of assets or contributions will be protected under the treaty. So I think that's where I see us really going in the future. But I'm certainly very curious and eager to hear from other panelists who are in an even better position to comment on that because they participate in these treaty negotiations.
Many thanks, Csaba, for your valuable opinions in respect of today and future of understanding and defining the term of definition in investment law. Our second speaker is Yulia Levashova. Yulia is an associate professor at Nyenrode Business University in the Netherlands and serves as the director of the Dispute Prevention Program at the Asia-Pacific FTI Network, with a particular focus on the Central Asian region. Her areas of expertise include international investment arbitration, commercial arbitration, corporate social responsibility, and due diligence. In addition to her academic work, Yulia is an independent practitioner acting as an arbitrator and providing legal consultancy to the Dutch government and international organizations, including UN, ECA, and UNCTAD. She has also served as an observer to the UNCTAD Working Group 3 on ISDS reform. Yulia is a member of the Chartered Institute of Arbitrators, ICC Netherlands, and the London Court of International Arbitration. She has published extensively on investment law, including a monograph on fair and equitable treatment. as well as co-edited volumes on investment law, environmental protection, and investor-state relations in a post-pandemic world. Yulia, welcome.
Thank you. It's a pleasure to be here.
Thank you. I have 3 questions to you too. My first question is on your expertise, FDI. How has state treaty practice surrounding the fair and equitable treatment, FET, standard evolved to address its historical controversies, particularly the shift from open-ended formulations toward more exhaustive lists of obligations?
Thank you very much for your kind introduction and for such a interesting question. I also want to thank Professor Manav, Özdemir for involving me in this webinar. It's a true pleasure to be here. So let me begin by explaining, first of all, why we choose to focus on the Fair and Equitable Treatment Standard, or FET. Well, first of all, FET remains, without question, still the most central treaty standard in international investment law. And that can be supported by a lot of statistical data. So, for example, according to United Nations Conference on Trade and Development, over 95% of all international investment agreements include a reference to FET. It's equally important in dispute settlement because approximately 85% of all investment cases involve a claim that FET was violated. So as lawyers often joke, if you don't know which treaty provision to plead, plead FET. So why is it so widely invoked? There are a number of reasons, but I think the most important one is that FET covers violations that would be difficult to argue under more specific standards, such as expropriation or non-discrimination. As one of the German scholars and practitioner, Roland Klacher, put it, and I really like this type of comparison, that fair and equitable treatment is like a black box full of surprises. You never know which one you will get. And despite that he has written that about 10 years ago, it's still pretty much true. So this type of unpredictability originates from how the clause has been formulated initially. So let me walk you through the 3 main approaches of how FET is formulated. First of all, I think it's not a secret. The most common way of include or formulate the fair and equitable treatment clause is by using autonomous undefined formulation. So in around about 80% of all investment agreement, FET is undefined. So the treaty does not really clarify what type of state conduct would amount to a breach. And this dates back to very first bilateral investment treaty between Pakistan and Germany of 1959, where it was simply put that each party shall at all times accord fair and equitable treatment. And many states followed this type of formulation, and it continued to be dominating way of describing FET standard. And of course, it is changing, and I will explain it as well. However, again, to repeat myself, in about 80% of all treaties, the same autonomous undefined formulation is still in use. So when tribunals try to interpret this type of autonomous formulation by primarily using Vienna Convention on the law of the treaties, they found themselves in difficult position doing little more than just identifying synonyms, so synonyms of what is fair and equitable. And that left them with the task of pretty much filling the content of this standard themselves. The second formulation, which has been used by a number of states, is to linking FET standard to either general international law or customer international law. And originally, this approach has been adopted by North American states, particularly the US, NAFTA countries, which tied FET to the minimum standard of treatment, clarifying that it does not require treatment beyond or in addition to, which is required by customer international law. And this approach appears in many of investment agreements, including a number of recent Turkish bilateral investment treaties. And the goal of linking FET to customer international law is to raise the bar for finding a breach. And that's because of the key reference is made to the very old decision Nyenrode against Mexico of 1926, which required state conduct to be shocking or outrageous in order to constitute the violation. And this so-called Nyenrode standard became highly influential for interpreting the minimum standard of treatment under customer international law. However, whether linking FET to the minimum standard actually raised the threshold for the breach of FET is still quite a disputed question. And the third approach, which we can find in number of new generation of international investment agreements, is to move toward great articulation of FET standard. And I think here there are a lot of parallels to what have been discussed by Csaba, by the first speaker, in terms of the definition of investment. So, for example, in the EU treaties with Canada, Vietnam, and Singapore, the approach is to exemplify the conduct which would violate the fair and equitable treatment standards. And those treaties specifically specify that the state would violate FET only if there was, for example, denial of justice, fundamental breach of due process or transparency, manifest arbitrariness, etc. So those new generation of agreements include pretty specific list of obligations. Some also refer to the legitimate expectation. It's also quite interesting because before we have not seen the reference to the legitimate expectation in the treaties. And now some of the treaties, for example, CETA, clarify that only specific assurances of investor can be protected under the treaty. So to summarize my answer, treaty practice is moving clearly towards greater clarification and refinement.
Thank you. So if we look at the past 5 years, what key trends have emerged in your view in respect of the FET standard in practice?
Thank you. Thank you for this excellent follow-up. I think there are a number of trends, but I will just mention 3 for the sake of time, and if there are questions, I can expand on that. And the first question is related to the tribunal's growing tribunal deference towards the state right to regulate. And here I need to maybe explain a little bit. Well, FET claims sometimes depends, but sometimes they arise in response of how states exercise their regulatory powers. For example, the revocation of license by the administrative body, change in the regulation or change in the legislations. So those are types of measures that in some cases investors challenge and claim that they would treat it unfairly because it would in one or another way affect the investment. And also significant number of those type of disputes also involve the public interest dimension. For example, the objective of the state to protect the climate measures or response to the crisis. And in the early days, most tribunals tended to avoid discussing the state right to regulate or public interest in their assessments. However, this approach has shifted, and a landmark moment was the 2006 decision and Saluko against Czech Republic case, which was the first decision to explicitly recognize the importance of the state's freedom to take regulatory measures. So in the past 5 years, tribunals have been put quite significant efforts. Of course, it depends on the case, on case-by-case basis, but if we're looking at the trends, effort to balance public interest and investors' right. So that could be detected in many decisions. And to this end, tribunals have pretty much acknowledged that the state's ability to change its laws is a significant part of the right to regulate. And in a growing number of decisions, also what we see is the stress that the measures, for example, adopted for the purpose in the legitimate public interest is also taken in consideration in assessing the fairness of the state conduct. I'm happy to expand on this point, maybe if we still have time in the webinar. So this is the trend number one. The trend number two, and I have touched upon that a little bit, is growing convergence of the interpretation of the autonomous FET standard and the minimum standard under customary international law. As I mentioned, some tribunals applied rather strict near against Mexico threshold, but lately I think more convergence can be observed. For example, in the case against Romania, Gabriel Resources against Romania, which was decided in 2024, the tribunal anonymously rejected the argument that the FET tied to customary international law require really shocking or outrageous conduct. So more and more tribunals recognize the evolving content of the customary international law. And the third trend, I would say, is the increasing significance of investors' due diligence. And it's usually related to the cases where the investor challenge the particular state measures which are based on the regulatory framework. And in this context, tribunals increasingly examine whether the investor conducted the proper due diligence before investing. And there are several decisions where the absence of due diligence by the investor has been really decisive in denying the protection under FET, or more specifically, the protection of legitimate expectations of the investor. I think I will stop here, and if you have more questions, I will be happy to answer them.
Yes, let me pick up from the first trend. As we all know, FET standard is very much related to right to regulate. So my third question is on that. To what extent has the FET standard adapted to accommodate states' right to regulate? and broader public interest objectives such as environmental protection and public health?
Thank you for this very important question. And to clarify again the trend which I mentioned already, so in the early cases, in the FET jurisprudence, especially in the early 2000s, the very broad scope of host state obligation has been established, which includes the obligation of the state to provide complete transparency, the protection of the legitimate expectations, the protection of stable and predictable legal framework, so setting the bar quite high for states in this respect. The contemporary approach has shifted, in my view, and quite considerably, because tribunals, as I mentioned already, at least in quite a significant portion of cases, not all, again, depends case-on-case basis, perform a balancing exercise between the states and investor interest, and by that developing what I would call a checklist approach. So when assessing the FET claim, tribunals often consider different type of questions. So for example, what type of commitment have been made to the investor? Were they clear? Is there a severity of the economic impact which was generated by the state measures? What is the extent and the context of the regulatory change? Whether the state has followed the proper procedure, whether the legitimate public interest was involved, maybe investor due diligence. So a lot of those type of questions have been very relevant in a number of cases where this type of balancing exercise has been provided. And this is far more balanced than the earlier case law. However, in my view, a certain issue remains because there's still not a clear methodology of how tribunals weigh those different factors against each other. And to this end, I would say that the decision of International Court of Justice of 2023 and certain Iranian assets became quite important. Not going into the details what the case is about, but it's an important case for the FET standard because it's the first time when it has offered some sort of interpretation relevant to the FET. And the court, in analyzing what constitute unreasonable state measures, relied on the proportionality test. So some arbitral tribunals have, of course, already employed proportionality analysis in various forms, but the practice has been quite inconsistent. So in this regard, International Court of Justice judgment might bring some greater coherence and encourage tribunals to adopt a structured method of review. So in this particular case, proportionality. Thank you very much. If you have more questions, I will be happy to answer them.
The questions are incoming, so we will ask at the end of the presentations. Bear with us. Thank you very much for insightful information you have provided to us. Our last speaker for today is Mr. Hasan Aslan Akpınar. He will be speaking on Turkey's International Investment Agreements Program, Lessons Learned for the Future. Hasan Bey, hoş geldiniz. Welcome.
Thank you very much.
Mr. Hasan Aslan Akpınar works as the head of International Relations Department at the Directorate General of Incentives and Foreign Investment under the Ministry of Industry and Technology. Mr. Akpınar serves as the head of Turkish team negotiating bilateral investment treaties as well as investment chapters under Turkey's free trade agreements. Mr. Akpınar was born in 1972 in Istanbul. He received a BA degree in International Relations from the Department of Economics of Istanbul University in 1994 and a Masters of Arts in Law and Diplomacy degree from the Fletcher School of Law and Diplomacy, Tufts University in 2003. Mr. Akpınar, I have a number of questions to you too. My first question is obviously on Turkish BIT model. So what is the new BIT model brings to us, and what are the main features of it?
Thank you very much. Thank you for the question. What are the new BIT draft brings us? Yeah, it brings many new things, many innovative features. You know, before going into details, maybe I would like to give you some information about how I started to negotiate BITs and what I witnessed so far. When I started negotiating BITs in 1997, as a junior expert, the whole international investment law was very different. At that time, for example, as Türkiye, we had a draft text of 10 pages only. And let me check my notes. It had only 12 articles. So basically, it was a draft text based on the classical examples of BITs, that is to say BITs designed by capital exporting countries. And after that, as Türkiye, we started to develop our own models based on the experience gained through negotiations, as well as experience gained through arbitral decisions. Until 2000s, there was no arbitral decisions, honestly. And at that time, really, as the investment treaty negotiators, we didn't know about the meanings of some certain principles, such as fair and equitable treatment or full protection and security. And also, please don't forget that when I started in 1997, the sources about international investment law were very limited. At that time, for example, we didn't have internet, for example. At that time, as far as I can remember, there was only one book printed by the UNCTAD about bilateral investment treaties. So, and it was very difficult to find case law. It was very difficult to find and read the decisions of arbitral tribunals. So with the development of technology, with the development of internet and other means of communication, through 2000s, we were able to read arbitral decisions. And when we started to read arbitral decisions, we started to learn that some principles or some definitions in the BITs has different meanings compared to what we had thought of. So starting 2000, the year 2000, we started to develop our own models. In 2006, we published another model. In 2008, in 2010, 2013, 2016, and our latest model was published in 2024, August of this year. So our new model, for example, has 20 articles compared to 12 articles of the model in 1991. And it also includes 2 annexes, one annex on expropriation and one annex on temporary safeguard measures. And we have some new added articles to our models. For example, right to regulate, minimum standard of treatment, corporate social responsibility, general exceptions, third-party funding, which is a very popular topic in these days, security for arbitration cost. This article is important in order to prevent frivolous claims that, as Turkey, we have experienced in the past. Denial of benefits clause, a clause, an article on transparency, an annex on expropriation. In this annex, we are explaining the difference between direct expropriation and indirect expropriation. And lastly, temporary safeguard measures. So in our new model, in addition to the inclusion of new articles, we have also included some new definitions. The definition of investment, the definition of investor are very important in order to define the scope of the agreement. And we have also added some other new definitions under the article on definitions. So now, in 1991, we had only 1 page of definitions, whereas in our new model, we have a 3 pages long definitions article. And most importantly, we have a new definition of investment in our new model. So basically, it's again an asset-based definition of investments we have. It's open-ended, but we have some additional criteria. And the most important of it is that, of course, we include Salini test to our definition of investment. And they include all the criteria, all the Salini criteria, because as you know, in some countries they don't include all the criteria listed under the Salini test. Sometimes they leave one of the criteria out, but we have chosen to include all the Salini criteria, starting with commitment of capital, expectation of gain or profit, assumption of risk, contribution to economic development. And I would like to underline this, many countries still, they don't include contribution to economic development as a criteria of investment. And certain duration. Certain duration also is important, we think that, because, there are many types of investments, and some types of investments are not durable. They come and they go very, very quickly, such as, hot currency movements or portfolio investments. In this world of internet and all the electronic means, we have applications in our cell phones, so we can buy and sell shares, instantly. But the important question here is that do we want to promote all types of investments, or do we only give protection to investments which are long-term, which have some benefits for the development of our countries? So because, based on this question, the definition of investment is very important. So also this new model of Türkiye takes into account the two roles of Türkiye. One role, we are a capital importing country, and the other role is we are a capital exporting country. So in our models, in our draft text, it's very important for us to be balanced, because Türkiye, for example, when we check out the foreign direct investment flows to Türkiye, since 2002, more than $200 billion of foreign direct investments flowed into Turkey, whereas FDI outflows from Türkiye amounted to $83 billion, almost half of the FDI inflow of Turkey. So today, wherever you go into the world, into any country, you can find the Turkish investments, especially in the Central Asia, Caucasus, in the Balkans, in the Middle East, in North Africa, even in the Sub-Saharan Africa, there are many Turkish investments. And these investments also need legal protection. Because of that, because of this dual role of Türkiye, in our model, we have taken into account the interest of Turkish investors as well as the interest of the Turkish state. And we have tried to keep a balance between these two roles. So Türkiye, here maybe I should also, if I have time, I would like to also underline the fact that bilateral investment treaties still they are important tools for the countries to protect their investments abroad. By the way, as an investment treaty negotiator, first and foremost, why we negotiate bilateral investment treaties? We negotiate BITs in order to give protection to our investors abroad. And we know that by signing bilateral investment treaties, it is very difficult to promote foreign direct investments flows. There are many researches made so far about the relations between the BITs and the impact of BITs on the investment promotion. The relation is very, very weak. So most importantly, when we sign BITs, we sign these treaties to protect our investments abroad. And still BITs are very popular. So before this conference, I checked UNCTAD's website. UNCTAD has a very good investment portal about bilateral investment treaties and other treaties. And I've seen that many countries, including developed ones, still they are negotiating bilateral investment treaties. For example, Japan. Only in 2026, Japan negotiated and signed 3 BITs with Serbia, Tajikistan, and Bangladesh. With Bangladesh, Japan signed actually an investment chapter under the economic partnership agreement. United Arab Emirates, for example, another very active BIT negotiator country. Russian Federation, Saudi Arabia, People's Republic of China, even Italy, an EU member country, they are still signing BITs. Italy signed BITs with Kyrgyzstan and Uzbekistan in 2025. Canada is another country negotiating BITs. So as Turkey, we are also still very active. So far, we have signed 115 BITs, and 89 BITs are in force. So this makes, in the last 5 years, only Turkey signed 11 bilateral investment treaties. But the important thing is that what you negotiate. I mean, do we still negotiate all type of treaties, or do we negotiate a new type of agreements having a new type of provisions? If you ask me, Turkey negotiates a modern BIT agreement, a modern type of BIT agreements based on our model, but we are also very flexible because different countries has different needs and different models, and negotiating is a very hard task. So being flexible is very important, and also I think Csaba commented on this and asked why the countries does not limit the scope of their definition of investment. I think he asked this question. And we are doing that. I mean, if you look at our new model, you will see that when we give a list of investments, we also give a list of what type of items, what type of assets are not covered by the definition of investments. So it's possible, I mean, even though you include an open-ended definition of investment, you can also give a list of items or assets which are not covered by the definition of investments. It's possible. Also, another maybe innovative feature of the new type of BITs is it is possible also to exclude some certain type of sectors from the coverage of ISDS, investment state dispute settlement. For example, tobacco sector is a problematic sector because of the late cases. Australia has a very famous case. I don't want to give the name of the company. So, for example, a country may choose to exclude tobacco sector from the coverage of ISDS. It's possible. So new ways of innovation is always possible. And of course, we have also experienced the Energy Charter Treaty modernization negotiations. I was also a member of Turkey's team during the Energy Charter Treaty modernization negotiations, and we have benefited from those negotiations. We have learned many new things, many new innovative provisions from those negotiations. Maybe I should stop here.
Thank you very much. I had a number of questions, but they are all responded by you. While you are here, there are 2 questions that you could answer, and we could get back to our other speakers for the queries came from public. Is the newest model available online? To 2025 24.
Yes, the new model is not available online, but it's also possible to reach the latest international agreements, BITs, from a couple of websites, including the website of Turkish Parliament. But if there is anybody who would like to see the full text of Turkey's new BIT model, if he can reach us, if he or she can reach me, only for academic purposes, we can send a copy of our model. Normally, we don't disseminate our draft models because if we keep it, let's say, I don't want to say confidential, it's not confidential, but if we don't publish it, it also gives us some freedom to update it from time to time, because a negotiation process is a very dynamic process, and in every negotiation you can learn some new things, you can experience some new important lessons. You can get some important lessons from each negotiation. And after each negotiation, we would like to sometimes to update our model. But if any academician is interested in our model, we can send a copy of it.
Thank you. There are while we are speaking, there are a number of questions that came to me.
Mm-hmm.
One of them is, as Turkey aims to become a regional dispute resolution hub, how might the feature of Turkish BITs be designed, particularly regarding ISDS and mediation as an alternative to arbitration?
Mm-hmm. Yes, this is a good question. As you know, as this question underlined, Turkey is trying to become a regional hub for ISDS, for international dispute settlement. We have a couple of arbitration centers, such as İTOTAM, İSTAK. We have also another center established under the Islamic Conference. Of course, in order to give some functioning to those regional centers, you should also make references to those centers in your bilateral investment treaties or other international investment agreements. In this respect, in our new model, we have made reference to İSTAK and İTOTAM arbitration centers. And we have also included a provision saying that if the parties agree on other centers, we can also include those centers. Also, the full name of the center that I mentioned is the Organization of Islamic Cooperation Arbitration Center, OICAC. This is another alternative mechanism listed under our new model. So in total, we have listed 3 international arbitration centers in Istanbul. İSTAK, Istanbul Arbitration Center, this is the first one. Then İTOTAM, Istanbul Chamber of Commerce Arbitration and Mediation Center. And the last one, OICAC, Organization of Islamic Cooperation Arbitration Center. We have also, as usual, we have ICSID. It's the most famous one. It's also possible to go to Assoc, arbitral tribunal established UNCITRAL rules. So I think this, this is the answer of that question, I guess. I cannot.
Thank you. I have 2 more questions. 3.
Mm-hmm.
Two, considering Turkey's position as a bridge jurisdiction between the EU and the neighboring regions, to what extent can its international investment agreements reflect or transmit EU-inspired regulatory standards in areas such as sustainability and investor obligations?
Our new model also takes into account investor obligations. And of course, the most important obligation is the following: the investment should be made in accordance with the laws and regulations of the host state. This is very important. In our models, we are saying that the investor should respect the laws and regulations of the host state. We shouldn't, the question is asking about these new principles as the principles advocated or underlined by the EU countries or the European Union. But, the important thing is that as capital exporting countries and capital importing countries, we should all include such type of new provisions into our bilateral investment treaties. Our new world has many problems, such as the protection of environment, the protection of labor rights, or the protection of consumer rights, etc. And during the negotiations, we should also take into account all these necessities, all these new needs of the world public. So we are also including such provisions. For example, in our new model, there's a reference to OECD's guidelines for multinational enterprises. We have an article called as corporate social responsibility, and we are saying that the parties should also promote its companies making investments in other countries to respect corporate social responsibility. So overall, we can say that the all types of investment treaties, those treaties were designed only to protect investors' rights. But the modern ones, the current bilateral investment treaties, they are trying to rebalance the rights of the public and the rights of the state against international investors. So when we look at the new treaties, including the treaties signed by Turkey, we will see that these are more balanced treaties. But of course, still we have some ways to go, and but also we also need time, because change, the new things, they also need some time to adjust. You cannot include many new provisions within a shortest period of time. We need some cases, case by case. I believe that the new type of BITs will be compared to old ones signed in 1980s, 1990s. The new BITs will take into account all those issues in great detail. But we will need some more time because during the negotiations, still we can see, we can observe some resistance from the other negotiators. You know, negotiation is a two-way of process. Of course, you cannot push only for your own model, and you cannot push the other country, your partner, to accept all the new provisions in a very short time. So it takes time. But in the end, it will happen, I guess.
Thank you. Thank you. And the last question is, Turkey has a substantial BIT network, yet many of these treaties predate the post-2011 shift toward more balanced investment agreements. What is the ministry's current approach to modernizing older BITs, and what priority criteria guide the negotiation agenda?
Mm-hmm. This is also a very good question. You know, yes, Turkey has many BITs to renegotiate and modernize, but it takes time. You know, first of all, it takes time because, first of all, you should also convince the other parties to come to the table and negotiate new modernized agreements. And this is very difficult. This is not very easy. I cannot give the name of a country, but currently we are negotiating with a country, very developed country. And this country was a very active country during the modernization of Energy Charter Treaty. And this country advocated some very new, very innovative provisions in those negotiations. But when we asked them to negotiate and modernize our bilateral investment treaty, they showed a very stiff resistance, a very strong resistance to negotiate a new type of bilateral investment treaty. So still, for example, we are trying to convince that country to launch negotiations to modernize our current bilateral investment treaty. It's difficult. What is our policy? Our ministry's policy is to negotiate as many as bilateral investment treaties to modernize and negotiate those agreements. And every year we are trying to negotiate at least 2 or 3 bilateral investment treaties. And so far we have succeeded in negotiating more than 20 bilateral investment treaties signed during the 1980s and 1990s. But as I said, it takes time. And sometimes in some cases, you can also terminate the bilateral investment treaties, and you can, instead of a BIT, you can negotiate an investment chapter under a free trade agreement, and that investment chapter may replace the old bilateral investment treaty. For example, with Korea and Singapore, we have adopted this approach. We have terminated old BITs with Korea and Singapore, but now we have very ambitious, very new modern investment chapters under the free trade agreements. But we have a program, but as I said, sometimes it's difficult to convince the other side to launch the negotiations. But there are some countries in the pipeline. So in the coming years, you will see more and more BITs renegotiated and modernized by our country.
Thank you very much, Hasan Bey. Now I have a question to Csaba. Csaba, are you with us? Okay, while Csaba
Yeah,
is...
I'm here. Apologies, took me a moment to get my camera back on.
Wonderful. Csaba, can digital assets be considered within the concept of investment?
It's a really interesting question, Professor. My instinct would be that very likely, yes. I think you would have to look at the definition of investment that a particular treaty provides. But as long as you are talking about a digital asset, and I think the key word there is obviously asset, the fact that it is digital and not necessarily physical would suggest to me that as long as there is a nexus with the host state's territory and your ownership of that asset is in fact in the host state as opposed to somewhere outside of that host state, I think there's a strong case to be made that that would fall under the definition of investment.
Thank you, Csaba. And I have a number of questions to Yulia. Yulia, the first question is about the FAT standard. It has been interpreted inconsistently across tribunals, ranging from a purely autonomous standard to one strictly tied to the customary international minimum standard. In your view, which interpretation is better and serves the dual goals of investor protection and host state regulatory freedom, and why?
Thank you for this question. If I understood the question correctly, the comparison should be made between the autonomous standard and minimum standard of treatment, and as how it was interpreted by tribunals, and which interpretation would serve best both parties. Please let me know if this is correct interpretation of the question.
Yes.
In my view, again, it's very much depends on the specific case, and on the facts of the case. So it's very difficult to make this type of generalization. But I would say that if we look at the interpretation, most of the interpretations which were made by the tribunals when the formulation, when the FET standard was linked to the minimum standard of treatment under customary international law, which the intention of the parties was to raise the threshold for the state misconduct. Number of tribunals have taken this seriously and actually made a pretty comprehensive analysis of what the minimum standard of treatment might mean, whether it has evolved, what kind of obligations it includes. So in this sense, it's really opened the door for more thorough analysis, and in many cases, it also leads to comprehensive assessment and more reasoned decision, I would say. So it's difficult to say whether it's benefit more investors or the states, but the short answer, at least based on many cases which I have analyzed, the formulation of which includes the reference to the customary international law, usually produce more reasoned decisions by the tribunals.
Thank you, Yulia. My second question is, in light of the International Court of Justice's recent climate advisory opinion, how do you think the recognition of states' positive obligations will affect investor state responsibilities?
Very important question. Unfortunately, I do not have the crystal ball to see how it will be affected in the future, but based on the different commentaries, the conversation with the colleagues, I think it probably will lead to the better understanding of the climate change obligations by the tribunals, because I do not think it will have a direct effect specifically on the assessment of FET standard, but perhaps more on the because tribunals do still refer to the International Court of Justice decisions. It's important, not in all cases, but in some cases it has been an important source in the assessment. So I assume that advisory opinion will be employed, perhaps also in the FET cases, which include some kind of climate change or environmental obligations, and perhaps also specifically in relations to the investor duty to conduct due diligence, because in the advisory opinion, the reference to the due diligence has been made quite explicit. So my expectation would be that not to the investors' due diligence, but in due diligence in general. So my expectations would be that perhaps that will serve some kind of inspiration and perhaps a source of assessment or evaluation which will be made by the future tribunals when the climate change obligations are part of the case.
Many thanks, Yulia. To what extent can the state's right to regulate and emerging investor obligations in human rights and environmental law reshape the interpretation of the FET standard?
I think that they already do, and we see that based on, first of all, modern treaties. And I think I would relate my answer pretty much to what Hasan has already explained, based on the example of the Turkey model BIT, which includes such innovative provisions as to corporate social responsibility, right to regulate, specific exceptions. So also the objective of the treaty, because before the objective was primarily to protect the investment. Nowadays, the modern treaties have really shifted, including sustainable development often is mentioned. And in this respect, when the tribunal interpret the FET standard, it consider the general context of the treaty, the objective of the treaty, how the FET is formulated. So in this respect, right to regulate, which is mentioned in the treaty, for example, the provision of the right to regulate corporate social responsibility is quite important also in the context of the interpretation of the FET standard. It is difficult to really support that by the empirical data because we have not so far many examples of the cases where it happened, because again, also back to my presentation, most of the FET cases are still based on the old generation of treaties. But I think in the future, we will see more of those type of balanced interpretation, which also include different considerations, such as, again, investor due diligence and the right to regulate, maybe specific reference to particular human rights law or maybe OECD guidelines, as also mentioned by Hassan. Also, if we look at the number of tribunal decisions, then we have seen already that host states legislation, for example, which protect environment, or even international obligations, have been often invoked by tribunals in assessing FET standard. There are many examples, but for example, I think quite a known case, Urbaser against Argentina, which involved contract claim. But if we look at the FET standard, there also tribunal has been mentioning the environmental and the legal framework in general of the state as an important factor in interpreting this standard. So there I think many interesting development in this sense, and human rights law and the investors' obligations have quite impact already on the decisions by the tribunals.
Thank you, Yulia. There seems to be no further questions to our speakers. We are thankful to our distinguished panel of speakers, Csaba, Rusznak, Professor Yulia Levashova, and Mr. Hasan Aslan Akpınar. We are also grateful to Turkish Arbitration Academy, Dispute Resolution Center of İbn Haldun University, Professors Eda Manav Özdemir, Yeliz Bozkurt Gümrükçüoğlu, and organizers of this event, Doctors Gülnihal Ahtar Yakacak, Ömer Faruk Kafalı, and our assistants Abdülmecit Güldağ and Yağızhan Kol. Thank you very much. Hope to see you next time in our next event.